Wow.
Are you gonna be in the office?
Yes.
Well, I turned in a couple of invoices for training to get paid. The guy called me yesterday, so he hasn't got paid yet.
Yeah, those just got approved at the last meeting. They haven't gone out yet.
Well, there was two sets of invoices,
Yeah.
so there should have been
So, yeah.
one like for $3,800.
Was it you that gave it to me or was it Derek? I think maybe Derek gave it to me at the end of last week or something.
One for $3,800 and then there was one for $2,000.
Right, those were the Sigma deposits.
Yeah,
Yep, those got transferred to the fire department.
but did the check get written to the vendor?
That, no,
Oh,
not yet. And Joanne is out of town until tomorrow night, so I can't even pay bills until she gets back.
okay. Well, my question is, do you have all the paperwork you need to write?
I think so, I'm pretty sure Derek gave me the package. Or you, was it, I think it was you, I think.
I
gave
give
me
you paperwork for the second one, I give Angela paperwork for the first one.
Oh, okay, she should have put it in there, it's probably in your file. I don't know, my head's been all over the place with so many different things going on.
So, all the way to Kentucky, Saturday and Sunday, and all back,
You did? They were back?
down and back. Take the youngest one down to my nieces,
Oh,
they live in South Carolina, they come up to me, and
yeah.
he gets to go ocean fishing for the next 6 weeks, so.
Joe's gonna make it.
Ready?
I'm ready, you ready?
Yeah, I've got 5:59 yet. Okay, please ensure your cell phones are either turned off or muted. Join me in the pledge. We'll open the meeting at 5:59 according to my clock. I pledge allegiance to the flag of the United States of America, to the republic for stand one nation under God, indivisible, with liberty and justice for all. We do have a quorum. I don't see Mr. Keys.
Yeah,
Is Joanna up on Zoom?
not yet. I'm not so sure she knows how to do that.
Okay, the agenda was supposed to be strictly STRs, but we do have a deadline for basically an understanding letter by the county MTA concerning the hospital. You're our representative, so I want to discuss that, and this deadline, they want a response by the 15th. Our next meeting is the 18th, so we'll deal with this now. Okay, anybody opposed to that? Okay, so we'll deal with that right off the bat. What this says is the county basically wants to hire a legal consultant. Please review, sign, and date the enclosed understanding letter to signify an agreement to jointly fund a legal consultant. Okay, kindly send it to the temporary point of contact, et cetera, et cetera. Okay, so basically they wanna, by signing this agreement, a jointly funded fund a legal consultant. This is not a commitment to any financial obligations at this stage. At this stage. Okay, so you have some.
I would recommend that we don't enforce any. What do you want to call it? And,
Agreed.
agree to it. The hospital board has spent a ton of money on this, everything shows it to be legal. And the problem I have with that is it says it consists of those in attendance. We don't even know if there was one township or two townships that agreed to this.
Right,
Oh,
well, the other thing, yeah. If not everybody agrees to this.
Yeah.
Then, the funds are distributed, or the bills will be distributed by those who do.
Yeah,
Okay, I can't see getting another lawyer involved. This is gonna be a ballot issue anyway.
it's
So it's
gonna end
gonna come
up
up
and
in-
go to the public. And just file it.
It'll go either on the August or the November ballot. So, do I hear a motion to sign this thing? Going once? Twice? Rejected. I will inform these people that it's a no. If I can get a pen. Okay, moving on. This is a workshop. Public comment will be limited to after we're finished here. I would like to get us out of here by 8:30. Anybody have any objections to that, whether we're done or not?
8 would be wonderful.
Okay, so we'll do it that way. If you, I see the printed copies have disappeared. I do have a couple other ones, if somebody doesn't have one, for what we've done so far to this point. Some of these are printed single page, just pass them out to whoever needs it.
Okay, thank you.
We all have. Okay, we left off at 606 conduct. I did have a couple changes prior to that. One was a suggestion to address larger gatherings for like family reunions. So under 12 occupants total.
Before you get to that,
What's that?
notice, there's a couple of things on the very first page. Intent was supposed to be changed to objective.
Okay. Yeah,
And then the bottom line, this ordinance shall not apply to use of property, and that should say occupied by the property owners,
no,
no?
the use of a property, by the property owners and their guests, doesn't fall under this at all.
Right, right.
Right, so if they use a
Whether they're
short-term rental,
occupied or not.
if they use a licensed short-term rental for that, okay,
This ordinance.
Then this
shall
doesn't
not
apply to them.
apply to use of
Okay, 'cause-
property
they're not gonna be renting it to their family.
by the property. Okay, I see what you're.
Okay,
I see what you're
the
saying.
intent of that was to make sure that if somebody's not living on the beach and they have a beach house, and they wanna get their family together for 4th of July or whatever, okay, that this, under a licensed STR, none of this applies.
The use of the property by the
Right.
property owner. Got it.
Okay, anything
I read
else?
that Differently in my head. No.
Okay, so we get back to 605 standards. I did move some of the things that were suggested to conduct, which was quiet hours, renters, tents. But the subject was brought up of family reunions, large gatherings. And I said, maybe we should make an allowance for a special request for that specific period of time, whether it's 7 or 10 days or whatever, for a weekend. We would have to, basically, come up with a document that would formally request an exemption from the cap limit of 12 that we put on here. And then figure out, well, you can't do this for the entire summer. So how many would we allow? So what I did was I wrote, exceptions to this limitation may be requested from the code enforcement officer and granted on a case-by-case basis, not to exceed 3 per calendar year. You don't have that?
And
Oh, yeah, you got it black. Okay.
when did you make that change? When did you make that addition?
Basically, I did that, before I sent that out, which is what, 2 days ago?
This was the only one I got.
Okay, so that's an item for discussion.
You don't have it either?
No, I didn't.
You have it, you
Yeah.
have the in red.
Yeah.
Well, maybe mine's just printed in black and white. Can you read it again? Exceptions to this limitation,
Here,
maybe you requested.
this one, I'll give you this one.
Because I've already made notes on this one.
This one should be red letter.
Fine.
There you go.
That's why I just didn't print it in color. I've got it.
Okay, so we're all dealing off the same page.
Yep.
Okay, as an amendment to 605(3)(c), I wrote exceptions to this limitation, which is the cap, the maximum number of people. Okay, may be requested from the code enforcement officer and granted on a case-by-case basis. In other words, tell us who you're entertaining, how long, et cetera. Not to exceed 3 granted per calendar year. Basically, what I was looking at was Memorial Day, 4th of July, if they use it, Labor Day, and then possibly colors or Thanksgiving or whatever, because this would apply basically to everybody. So the cap on as 12 occupants total per unit would remain in effect unless requested to be exempt. And if there was a problem with that, basically the code enforcement officer would basically notify the board. And we would make a decision on that. So if that language is sufficient, we would need to come up with an exemption request form. And, basically adopt this language, which would, I know there were a few people that, a couple people that said what they have, families that come up here on an annual basis that would exceed this capacity limit. So that takes that into consideration.
I'm just looking at, you've got the maximum number of short-term rental occupants shall be the lesser of. And then down, see, you say 12 occupants total.
Well, that's what we adopted at the last meeting. Okay, and now. This should be. In R1 only.
Yeah, I think that's what I was trying to look for, did I make notes on that, because I thought we did say that was already on there. Because we talked about other places, there would
Right.
definitely be room.
So technically, this should be moved up to limitations on the R1 districts as item number 2. The cap limit. Because if you're in agriculture or whatever, I mean. Family reunion, which I know happens. But this would be for R1 to basically cap the number of guests there. On the beaches. Which would be pretty much Hoyles and Clearwater. Or Caribbean Beach Road.
Yeah,
Suggestion?
no, I just leave it right there and just write in parentheses R1 only.
Right.
And
I think
Leave it right there,
for clarity, it would be better to have all the R1 stuff just
Yeah,
in an
same.
R1.
On limitations,
Section.
R1 zone district, I would just move this with that language up to item 2 and 604.
Otherwise, you're looking all over the ordinance for what applies to R1.
you make that item 2.
Yes. Item
Okay.
2 of 6.04.
Okay, the other one, this is from the lawyer's letter. insurance, which I didn't think of.
Oh,
Item B, insurance. The property owner must provide adequate landlord type insurance to protect all parties involved, the renters and neighbors, Clearwater Township, from hazards and accidents. A certificate of insurance must be submitted with each application. Each application would be for a separate unit, so those units, it could be the same certificate for several units. But every application needs a copy of the insurance certificate with that application.
Correct.
Okay, any objections to that?
no.
Okay, now we're down to reviewed and amended to this point. Conduct, I moved several of the items, and the quiet hours, overnight capacity, or overnight campers, RVs, tents, all that good stuff. Secondary dwelling on a single parcel may be used as short-term rental provided it has separate requirements. Those, I believe, were there originally. No, they weren't. Those were moved because pets started the old one. So that was just a moving from six, or, you know, I don't have my noted, my squirrel sheet with them. So that was from standards to conduct, which was suggested by you, and that's been done. Anybody have any language corrections for conduct down to the end of the first page, which would be campfires? I did add item B of fire extinguisher to the campfires, which I neglected to do. Campfire or charged hose shall be located within 10 feet of any fire pit. That was also a recommendation by the lawyer, which was oversight by me. Fire pit be located no less than 10 feet from any structure or other combustible material other than firewood. Be under the supervision of an adult at all times and be fully extinguished prior to leaving the fire. That was basically the standard language that I had in the original document. Getting to item 6. This was an addition. I moved this from, I can't remember where. I think it was from one of the first 2 pages. Respect for the neighbors and the community is essential. Trespassing, excessive noise, trash, and parking complaints will be investigated, and citations and or violations will be issued to the owner, renter, or both. That's basically just a statement of fact. 7, a visitor guide to the expected conduct of renters and guests shall be provided to each renter and posted within each rental unit. The zoning administrator or code enforcement officer shall provide copies sufficient upon issuing a license. One would go to the owner. The other one would be for that particular unit. Any objections there?
No.
Okay, then we get into septic and well status. I did have a couple of new emails concerning RVs, campers, so I want to go over this because this ordinance right now includes RVs and campers. Okay, a septic and well status report shall include the following. And this language was sort of modified a little bit by what the lawyer recommended. The septic and well status report from the Calcasieu County Health Department shall clearly indicate the number of legally conforming bedrooms the system was designed and permitted for under the standards of the Calcasieu County Health Department's environmental health regulations. when permitted and built. Okay, so what the septic system will provide bedroom wise will sustain. Okay, that caps the number of bedrooms, which also caps the number of people. So that regard, that is for basically all except for R1, which the maximum capacity in R1 has been decided to be 12 people. Unless there is a special circumstance that is requested and permitted. Okay, for septic systems that were permitted or last inspected more than 5 years prior to the application, the township may require further report from the Calcasieu County Health Department or a qualified third-party contractor indicating that the septic system and well is in good operational status, and that would also basically decide the number of bedrooms it can support, which again goes to the capacity limit. Anybody have any problems with that portion? Now, with regard to the comment from Mr. Sorensen here, justification to preclude RVs and trailers as short-term rentals in Clearwater Township. This precludes it.
Well, I agree with that. RVs and campers are not made for long-term use.
I understand.
And, you know, I've RV'd and camped since 1973, and I've yet to see a septic system that's designed to handle dumping 100 gallons to 40 gallons at a time.
Okay, so what I'm trying to say is, do you believe that they're not being used for this purpose
Question.
in Clearwater Township?
I know they're being used for that,
Okay,
but what I'm saying is, there's not a septic system out there that's designed to handle an RV.
right. So any application for use of those would be denied, correct?
I would. You know, I would say right in here that RVs and campers are not permitted. Just on their
Okay,
own,
so you
they're
want-
not a permanent structure.
I mean, yeah, residents can't even stay in their camper for more than a year while they're constructing their home. Nobody, 2 years ago, nobody's allowed to stay in a camper in the community, so how
Okay,
do we know that they are?
so basically, how do you enforce that?
Right,
When Arwood Trail ends up with 4 RVs on the corner lot there across from the boat launch,
Not this year.
okay? And they are all supposed to be quote relatives unquote, which I know they're not.
No, I agree.
Okay, so how do we regulate that?
Because
Basically with this, if we include the RVs and campers, we can write a violation. Okay, either way. Whether they apply for, I mean, if they apply for it, then the thing has. Do we have any pumping stations in Clearwater? Or one at the boat ramp?
we do now at the marketplace.
Kevin area, I've got one out there for us.
And I know Whitewater Township has one, but
That's campground.
yeah. So,
One way to stop, you know, we could, it's no RVs or campers are to be hooked into any residential
right,
septic system.
okay. So
That's
basically,
one way to tell whether they're
So-
staying there a long time or not.
what we
I don't know
need
how
to
I feel
do,
about that, because, you know, my parents are actually living in their camper on my sister's home, and their camper is hooked up to
yeah,
the
are they,
septic system.
yeah, are they living in it?
Yeah,
Okay, they're not renting it
6
out as a
months out of the
short-term.
year, yeah.
Okay, so that's the issue. So what we have to do is discern between people who are actually using this for a living space and people are using these basically as a short-term rental.
So you would say it's allowable for, oh no, do you need the other copy now?
No, I got it.
It's allowable for people who own it, but it's not allowed for people who are renting it, is that what you're saying?
Right, because if they own it, they have a septic system that's set up for them. If they're living in it, okay, they have to have something to do with the waste. Okay? So either they have a septic system on the property and a well, or they wouldn't be living there.
Right. Well, it does the ordinance for campers, is that for all of Clearwater Township, or is that just in?
No, that would be for all of Clearwater Township. Basically, if you're gonna rent out an RV, a camper, or
I mean, just living it.
fifth wheeler, okay, for profit, you need to apply for a license and you need to have some way to get rid of that waste that complies with basically our septic requirements, which means you need to either tie into a septic system or dispose of it elsewhere. But the only way we can ensure to do that is to include them in this. Otherwise, you'll have RVs and campers popping up everywhere. So if we don't include them, we can't regulate them.
Well, go back to the 2-year thing. If they don't have a valid building permit, they don't have a reason to be there.
That's not always true. Because there are several trailers and campers in this township that are set up for hunting season, summer residents by property owners. I don't know if they're rented out or not, but
I'm just saying, by the ordinance that we have out there, it says that
Right.
you can't live in an RV
well,
only for as long as the house is being constructed.
is that in residential districts or
I don't
all
know.
land use? So I'd have to go back and look at that.
Yeah.
As far as that. So for the intent and purpose, the objective is to regulate short-term rentals. If an RV or camper is set up in the summertime for strictly that purpose, they have to apply for a license and they have to abide by the septic regulations or use basically a pumping station somewhere. So if they're hooked into the septic system, we have to make sure that septic system is designed to handle the extra bedroom.
I mean, if you get on the Airbnb app, you're gonna find tents, you're gonna find
I know,
vacant land,
I
you're
know.
gonna find
and
campers.
the only way to bring them in is to include them in this order. Okay, that's my whole point. So now, at the end of this, we could probably tack on that RVs and campers.
Under the septic and well.
And tents. The fact of the matter is that tent would not qualify as a dwelling. A living space. But we could tack on at the end of this,
In our-
RVs and campers are included in this section.
Well, you have in the definitions, under dwelling unit, you include for the purpose of short-term rentals, a dwelling unit shall include recreational vehicles and campers.
Yeah. Okay,
So then there should be a complete separate section for regulations for that.
so we would add it to septic and well status.
Not. I'm saying an entire separate section
For RVs and
for
campers.
RVs and campers. Because, again, you know, if it's labeled septic and well, that's what that section is dealing with. And so if you include another thing in that section, it doesn't belong there. Just for clarity.
So I won't.
Yeah, is the camper,
License
RV.
required, okay, article, sex licensing. An owner of any dwelling unit located within Clearwater Township or authorized agent shall not rent or allow to be rented a dwelling unit or a portion thereof to another person for less than 30 days at a time unless the owner or the owner's authorized agent has obtained a short-term rental license for that dwelling unit in accordance with the requirements of this ordinance. This shall include recreational vehicles and campers. Right there under license. Does that satisfy,
Where are you rating that in? That
601,
601? Yeah,
item 1, just included on, as a last sentence to, number 1. This shall include RVs and campers.
And then in septic and well, then you wanna include special
Right,
instructions for RVs.
so now we get back to where we were. Okay, this basically just defines what we want for, septic and well status. The
So
license
items-
holder has the responsibility to keep the septic system in good operational status and to address all malfunctions in a timely manner. If a septic system malfunction occurs and is not corrected within a reasonable time, not to exceed 3 days, short-term rental of the property shall be immediately discontinued and the township notified of the malfunction. The use of the property as a short-term rental shall not resume until the malfunction is corrected in accordance with the Calacaska County Health Department requirements and written verification provided to the township. I also should include, well, no, Calacaska County Health Department's the contractor would repair from a plumber or a contractor, licensed contractor would do also. All right, so that addresses malfunctions. So if somebody rented a thing and the toilet was overflowing and they couldn't get a hold of the owner or the owner's agent and they called our office. Okay, basically, what we would have to do is send somebody out there to fix it, notify the owner and say, you're getting a bill. And until you,
But you're putting up the responsibility on the taxpayers to pay for that person's.
no. You just
I
don't,
know it would be
just tell them,
reimbursed.
just tell them, okay, we're
But
gonna
that's
send
also-
somebody out there
That's also putting the responsibility on our maintenance.
to fix this thing, otherwise, your short-term rental is terminated. Period.
Yeah, I don't think it should be the township's responsibility.
No.
If somebody has a septic system that's out there and it's not meeting requirements and they keep using it, yeah, I think your first notice to them
Well, yeah,
is their permit is suspended until the problem's
Right.
fixed.
so we go back to.
For President Biden as he fights to put concerns about his campaign.
There is no public comment at this time.
Okay, the use of property, the short-term rental shall not be done until the malpractice. So basically, the township's responsibility is basically to notify the owner. And, just tell the renter. We've done what we can, So the remedy would fall upon the owner as soon as somebody could get a hold of them. But the only reason we would get a call is if the renter couldn't get a hold of the owner's agent, caretaker, or the owner himself. So basically, all our office could do would be to recommend a plumber.
Plumber and.
Okay, here, call this number.
You know,
And send the bill to the owner, deduct it for your bill. So anyway. I don't see anything we could add or subtract to that. And again, I'm sure there's gonna be some bugs in this system that we're gonna have to work out down the road. Say this. Okay, so somebody applies, on part C, applies for, something where there is no, well and septic permit on file with the Calcasas County Health Department. Or the owner of a proposed short-term rental intends to replace the on-site septic disposal system to conduct the short-term rental. In other words, they've got a drain field, but it's not verifiable. Okay, the township may issue a short-term rental license for the current calendar year only, subject to the following.
Which that would not be D, that would be a continuation of C.
What's that?
Subject to the following, that would not be D, it would be a continuation of
Right,
C.
right. Would be basically item 1. Units requiring a new inspection of the system by a licensed contractor shall provide a new septic and well status report as defined in this ordinance. The new report will be used to determine the number of legally conforming bedrooms again. Provided the inspector has found the system in good operational status. The applicant shall then provide a copy of a current permit issued by the Calcasas County Health Department for any replacement or upgrade of the on-site septic disposal system. And I guess we could strike to meet all current standards because the permit would take care of that. Owner, agent, and I
Wait, you
added
still have-
agent.
You haven't added the RV campers to this,
Oh, let's see.
so that would be number 2.
Yeah. To,
Then you're gonna give us wording for that.
okay, basically, any RV or camper,
List of something or something.
um. What is that used as an STR? Or licensed as an NCR? Any RV or camper application for a license. These. So. Any RV or camper application for a license should, for a license as an STR is subject to these requirements. Does that sound better? Single sentence that covers.
All of the same requirements. That would.
Okay,
I thought-
any RV or camper, application for a license. Application for a license as a short-term rental is subject to these requirements.
I thought you were gonna reword that to say that they could take it and have it emptied or. Well,
Right, basically,
both. put in a septic just for that.
Well, that's the common. That would be the best right there, and if you're gonna use a camper or an RV, it has to have its own
Off-site pumping
stand,
station.
its own standalone septic system, whether it's a drain field, septic, or just a 1,000-gallon tank, holding tank and get pumped out, you know. And you don't have to worry about it overloading the residential one
Right,
year round, you know.
okay, so I could add, here, a holding tank or off-site,
Its own standalone septic system.
right?
You know, they, most of these places along here don't have enough room to put in a septic system in a
Right,
drain field.
okay, so as part of this, that's gonna be two, so two dash, I guess little a would be, a holding tank or off-site disposal.
I think it needs to be stated in there that they're not allowed to tie into the residential structure.
Okay. Now. That's different too. When I had my septic field installed, I put basically, an access on the outside of the house, 10 feet away from my septic system for expressly that purpose. Never used it, but I mean, it's there. So, but that system is so oversized. Okay, so we'll play with that. So we're looking at 607 RVs and campers. So I'll have to come up with something there that covers either tying into the existing septic system, if it meets the requirements, or holding tank or off-site disposal in lieu of. All right, so I'll rewrite that and put it in red for final review, and then ship it off to the legal and let them put in their 2 cents worth, and then we'll have to hold a public hearing. And everybody will get their 2 cents worth there. Okay, owner, agent, emergency response. I added agent to every place you see an owner or a caretaker that I could find. The license holder, owner's agent, or caretaker representing the property owner must be available by telephone, and the license holder, caretaker, or their authorized agent must be physically located within a 60-minute travel distance of the property in the event of an emergency or an issue that requires immediate attention. When notified of an issue of immediate concern by a Clearwater Township Code Enforcement Officer or a law enforcement officer, such issues may include but are not limited to law or ordinance violations, fire or medical emergencies. The license holder or caretaker shall take reasonable steps to resolve the issue within 1 hour of notification, will provide details of such steps taken to resolve the issue upon the request of the Clearwater Township Code Enforcement Officer. Issues of a non-immediate concern. Such issues may include but are not limited to failure to include license number advertisements or incorrect guest capacity included in advertisements shall be satisfactorily addressed within 2 business days. So the VRBO or kayak or Airbnb that says we've got a new little house on 50 foot of frontage on Porch Lake that whose capacity is 34 individuals, will have to be corrected.
I did have some people address this number one, 60-minute travel distance.
Right,
At the last meeting, they said if I live more than an hour away, I have to hire somebody to be a caretaker or an agent. I only live in Grand Rapids. It only takes me 2.5 hours to get here. I can get here
okay,
quickly,
well, if the place is on fire.
right? I mean, not anything they're gonna be able to do whether they're an hour away or 2.5 hours away if it's on fire.
But at the same time,
So what,
now they have guests that are out of a place to live.
Well, to answer your question there, with the fire department, we do a lot with that, and
yeah,
you call them and they'll say they're in Fort Wayne, but they have a key holder that's local.
yeah.
And, you know,
Yeah, that's why I'm saying just like the 60 minutes to 3 hours.
Basically, it's just
What kind of emergencies are you looking for them to come and be there on the property to address? That they have to be within an hour? What are your thoughts there?
basically, I'm looking at a fire, medical emergency,
loss of power,
yeah,
water well quit,
that's,
you know,
yeah, a septic problem.
except, you know, anything that would cause.
Anything that would be of immediate concern to the renter,
Runner,
the
you
guy
know,
who's paying the money,
Well,
that,
we're not responsible for that.
no, I understand that, but what I'm saying is, if, say we get a call from the fire department.
I mean, the fire department's gonna go anyways, right?
right, but well, we run into problems is most of these places have. one.
So they wanna know who to contact. All right, if we get the call, we have to be able to get a hold of the owner.
Well, we have all that stuff on file, right, in their
Right.
application.
Right,
So what I'm saying is, do they have to be physically there?
somebody has,
Some key holder should be here with
if
this,
it's
whether they are
license
there.
holder, owner's agent, or caretaker representing the property.
You
We want somebody that, if we have a problem, so that they can at least come out and confirm that, A, there is a problem. Okay, and B, get a hold of the owner if we can, and say, well, you gotta fix this now. Okay,
I mean, all of that stuff can be done over the phone. You can hire somebody
Right.
right,
immediately.
Well, I agree with what you're saying there, you know, most of it can be handled over the phone.
Yeah.
Yeah.
That's why I'm saying,
But
does
if
it
you
have
put it-
to be an hour?
Well, if you don't put a number there.
Yeah, oh, yeah,
they
sure.
can
I
say,
mean,
you know.
an hour's not very far away.
No,
That's Traverse City.
well,
good day.
Yeah,
Gaylord,
right.
really. But the other thing is, some boat runs into the guy's dock. Basically, rudes a jet ski or, you know, something like that, where you have to get a hold of somebody and say, look, we got a problem over here. That you might want to be made aware of. But,
Would it help if we changed physically located to 60-minute contact time?
I think that would be better.
You know, we can't get
I
a hold.
mean, we want them to be, yes, we want them to be available for emergency
well,
response.
what we
But do
want,
they have to
what we
in
want is
person be there?
is a contact that's fairly local.
Right.
Okay, that can resolve an immediate issue. Such as a septic system malfunction or maybe a well pump that died or whatever. The renter should be able to get a hold of them. But at some point, we're gonna get a phone call, I would imagine. So we just need,
I understand your thought
We just need
process on that, but I don't understand why we're regulating how they
all we're doing,
operate.
all we're doing is making sure that we have the phone number of course, that's all on the application.
Yeah,
anyway.
that's required,
So you're saying this is redundant, except for the fact that
that you're
Yes,
giving them
the owner or the representative needs to be on that property. for some reason, we're covered here.
Even if they live 60 minutes away, it might take them all day to get there, you know? So,
Well, it depends on what the emergency is too.
right,
So,
and how it's.
so you're saying we don't need that at all?
I mean, if you're gonna, I like what Greg said,
Agent must be
reachable or
within contact within 60 minutes,
in the case of an emergency.
you know.
Okay, agent, actually. Let's get rid of the located.
Okay.
Agent must be. All right, so if we put able to respond. Within 60 minutes, that covers
Yeah,
either physically or by a phone call to
Right,
resolve an
yeah.
issue.
I like that.
Then 60 minutes after
Move on to the next. Yep.
notification. Patient of an emergency that requires immediate attention. Okay, so you write that one. All right, when notified of an issue of immediate concern, the code enforcement or law enforcement officer such issues and ordinance violations, fire medical. The license holder or caretaker shall take reasonable steps to resolve the issue within 1 hour of notification. Reasonable steps. Provide details. Okay, so that would determine whether or not that STR is available to be rented. Or if there's gonna be a gap in the, like I say, the fire. So we know that there's not supposed to be anybody in there until, whatever issue needs to be addressed is resolved. Issues of a immediate concern. Failure to include license number and advertisements, okay. That's just basically, response time. So we would we've already said, somebody needs to be able to respond within 60 minutes of, notification of an emergency. So that, 1 hour is basically redundant.
Oh, yeah, I guess so. Kind of says the same thing now, doesn't it?
Okay, so we could scratch probably everything down to issues of a non-immediate concern, such as issues that may include but are not limited to failure to include a license number and advertisements.
Well, you do have that portion in there saying that they need to take reasonable steps to resolve the issue and then provide details of those
Right,
steps.
I think that should stay,
Yeah, I
so
think that should stay
the
too.
code enforcement officer knows what's going
right.
on.
Yeah,
So when somebody stops them on the street and says, blah, 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 you know,
yeah, what are they doing about this?
Or the neighbor's call.
yeah.
Yep, because the neighbors say they're gonna call, that's what I'm reading on the
Okay.
comments.
So that's fine. So basically, okay. So basically, if there's some sort of emergency, we get a hold of the caretaker or the agent.
Mhm.
The agent, calls a plumber. Okay, basically notifies the code enforcement officer that they've hired a plumber and the situation should be
Yeah.
resolved.
Sounds good.
Okay, 609. License number record, the unique short-term rental license number issued by the township shall be included in any advertisement for the rental. The street address for the short-term rental shall be assigned in accordance with the Calcasieu County Street Road number. In other words, we're gonna use the address that's listed as far as street addresses so that they are represented in an advertisement appropriately, so we know which property and which license number we're dealing with. So if there is a problem with the advertisement, we know exactly which unit it is. That's what that's for.
How will that work?
Where?
RVs.
What's that?
How would that work with RVs and those types of things?
The address of the property,
Yeah.
tax ID number, the tax ID number is gonna be on the application anyway, so. Okay, hold your comments until after we're finished or tired of this. Applicable rules, license holder caretaker shall provide written notification to an occupant and or guest of all rules of this ordinance and the renter and the property owner may be cited for a violation of this ordinance, the township noise ordinance, township fireworks ordinance as amended, in addition to any other remedies available to the township. Okay, so what that means is we are responsible for providing the owner and the owner's renters, or at least the unit, a copy of these ordinances and this ordinance. So any rules of conduct, there's no question about it. If there's a citation written by the code enforcement officer or a law enforcement officer concerning any one of these ordinances, okay, they will cite them book, chapter, and verse, so that the owner and the renter can go and look this up, any of the ordinances, and find out exactly why they got a citation.
For some reason I have noted on here that that's repeated. It must have been repeated from somewhere else. I'm not really sure where. I didn't write down where.
It might be under enforcement. Okay. Okay, 611. Okay, we noted that Mr. Keys joined 55 minutes into the meeting, workshop. Okay, violations, fines, suspension, violation notice. That's where you might find this repeated. If the Clearwater Township Code Enforcement Officer has reason to believe the
Sorry, I found it. It's back under 606, number 6, under the respect for neighbors, that's violations will be issued for excessive noise, trash, parking complaints, it's like,
okay, that should be,
that's, yeah, that's just saying the same thing under the applicable rules. It is,
well, this covers
it's fine.
written notification of those rules. Okay, so in other words, they have to know,
Those are ordinances and
Right.
they should know, yeah.
they have to know what we're talking about. Okay, if the township code enforcement officer has reason to believe that the application material on which a license was issued could contain false, incorrect, or misleading information and or statements, or that the short-term rental no longer complies with the standards contained in this ordinance, the Clearwater Township Code Enforcement Officer may, but is not required to, prepare or cause to be, this is from legal, cause to be prepared a written notice of a fine or suspension, some of this language is in it. Any such notice must contain detailed reasons for the fine or suspension, including but not limited to date, time, and statement of the incidents in violation of the ordinance. Service of notice. The written notice, along with the date, time, and place, shall be served on the license holder, agent, or caretaker by email, personally, or by certified or registered mail. A hearing before the Clearwater Township Board to occur no later than 21 days, calendar days from the date of the fine or suspension may be requested by the owner. So we can explain to him what the problem is. Him or her. Violation hearing. This is basically boilerplate coming out of our other ordinances. Any violation notice once prepared and served, the Township Board may hold a hearing at which time the license holder, agent, or caretaker shall have the opportunity to show cause why a fine should not be levied or why the short-term rental license issued under this ordinance should be reinstated. At the hearing before the Township Board, the license holder and caretaker shall be given an opportunity to address adverse witnesses. I don't like that terminology. To address adverse witness complaints, I guess, would be. We don't want somebody,
Want to keep it simple, yeah, just change the wording.
so adverse witness complaints, I would add that. So in other words, you're not standing here, having two neighbors argue with each other.
Well, I believe that that is the legal terminology for your right to confront those who have made
I
that
understand that.
accusation against you. That's why it's said that way.
Okay, so adverse witness complaints, meaning. So what, you have to have,
That's saying that I have the right to tell you that what you're complaining about is not actually true.
well, that's true, but. You know, the witness
Or
complaints are
whatever.
usually
Whatever
by email.
I'm a little concerned about this entire section myself, but, first of all, I wanna go back to, legal guidelines for code enforcement escalation procedure. And it's supposed to be verbal warning,
Right,
letter of warning,
right,
ordinance violation notice, legal letter of warning, then civil infraction citation. There's 5. That's the legal procedure for violation.
Yeah, we need to look at that.
That's the training I took, and it was, several attorneys that were discussing
Wow.
ordinance violation.
And it's 5 steps.
Mhm.
okay, you have. Basically,
So you can't just give them a citation and then call them in for a hearing. You have to go through the 5 steps.
all right, clip that and email it to me, I'll
Okay,
stick it in somewhere.
Now,
Now, as
also,
far as,
it says any notice of violation has to include the exact identification of the ordinance that's in violation.
yes,
The municipality has the burden of proof. We have to have documentation, photos, testimony, statements, and adequately describe the violation. And the goal is voluntary compliance. That's what they said in that
Oh,
legal
yeah.
training that I went through.
I'm
The burden of proof is on us,
talking,
not on them. They don't have to prove that they didn't do it. We have to prove that they did.
yes. And basically what you're dealing with is pretty much, noise
Mhm.
violation, vandalism. Okay, which that would be a neighbor reporting.
The same is gonna apply to this ordinance as well. It's an ordinance.
Yes, I know that. But, and then, the fireworks.
I don't think you probably wanna put that in here,
Hmm.
but you do say, you know, you're gonna get the violation notice and the service notice, and then you're gonna have a hearing.
Okay, so,
You're
so
giving a
that-
here,
the-
you're.
yeah, the proper procedure, basically.
Mhm.
The service of notice, okay, the written notice along with time, date, and place shall be served. Okay, so that's basically what I told the deputy Creighton.
Mhm.
Okay, so be nice. Okay, first thing, you go give somebody a verbal warning. And he's been enforcing our noise ordinance.
Mhm.
Okay. The second time you come and say, you know, you're gonna get a ticket for this if you persist. The third time he goes, so he's been there twice already, so the third time he writes a citation,
Mhm.
okay? He's there, he's a witness to
Mhm.
whatever, and basically he writes down according to, and I don't know if you saw the last citation he wrote, which he sent and I forwarded to everybody. Book, chapter and verse of the noise ordinance, which section, the incident violated, so.
Happened to be fireworks that were going off until midnight. Just kidding, yeah,
So, yeah, but now we're talking about, a license that has basically been issued by the township, for which an application fee was paid,
mhm.
for which, an annual license fee has been paid. So yes, those steps legally should be in this
Yeah,
ordinance.
I'll definitely send that to you.
Okay, so now we're at the hearing.
Item number 1, violation notice, you have written in there, the code enforcement officer may, but is not required to, and the attorney said that that notion that they may, but is not required to issue a fine, it seems, to give them a certain amount of discretion where they could arbitrarily enforce or not enforce.
Okay,
So you don't wanna give them,
you don't want to give them that latitude.
no.
Okay, so code enforcement officer
Just
is required.
Is required or may?
It just, no, you get,
Oh, is required to prepare.
is
a cause to
required to
prepare.
prepare a cause to prepare a written notice of a fine or suspension. Okay, so that would be after he's investigated,
Right.
okay, find out there is a violation and then notified the owner, agent or caretaker, and nothing was done about
And then on your service of notice, it's talking about the whole idea of emailing them. You should not include email because email goes to junk folders, email's not
it.
checked
That's true,
regularly.
that's true.
They
That
can
was
say
brought
they
up,
never got it.
that was brought up by somebody else. Okay, so caretaker, basically get rid of by email, personally or by certified or registered mail. Okay, personally would be face to face or a phone call. Okay, hearing report clear on 121 days. Okay, so now we're back to the owner, license holder, and or caretaker shall be given an opportunity to address the adverse witness complaints, is the way I have it modified. Okay, so basically, what you're saying is if they request a hearing, we have to request the witness,
Yeah,
all right?
and they're also allowed to bring witnesses themselves.
So if the witness doesn't show up, what, there's no hearing?
Okay.
Now, if there's no witness, there has to be some documentation of the incident, which is what. But there wouldn't be a citation written if there wasn't.
Well, there's gotta be some sort of record.
Right, there's
I
has to be
want
something to fall back on that's basically hard copy.
I wanna know what kind of position this is putting the board in as well. If we are going to be continuously in hearings with SDR because of issues or complaints, or we have to bring them in,
Well,
you're putting the board in a position to have to be in court and be full-time hearings.
No, I think that's where.
Actually,
Yeah,
Yeah, he represents the township.
so it would be a legal court hearing at the court, not
Right.
here.
right. Right,
And
so
I think the way
basically,
that that's written is that we're going to hold the hearing. That's the
Right.
way I read it. We're not
okay,
holding
that's
it.
a question for the attorney, I guess.
Okay. That's what it says, at the hearing before the township.
No,
board.
hang on, yeah, but.
I mean, I hope that it's not continuous violations, I really hope not, but
Well, it's,
if
Well-
you have 20 violations, you've got the board called
Right
to
there where it
special
says
meetings with
township
20.
board, but the attorney is
Right.
representing the board. You know, the board physically doesn't have to get involved.
right,
You assign that to your attorney to represent the board.
And then we pay the attorney for every time he has to come and do a hearing.
Well, if
That
they're found
doesn't-
in violation, then you can tax it, they'll want to.
Yeah, you better look at your violation cost, your fines. Cause if it's gonna have to cover court costs, you wanna make sure it says that. Or attorney fees.
okay, so,
Just things to think about.
basically call legal on this language, you see what they. Well, they would fix it. Because you have to give somebody who you've written a citation or violation upon, you know, some form of,
Won't they go to the county?
some way to address the situation if he feels he's been being picked on, or this was an error, or.
Yeah, it's your intention to avoid taking this to the court and just
That's basically,
levy fines and fees.
like I said, most of this from here on out was boilerplate from our other ordinances, including zoning ordinance 22,
Wow.
the noise ordinance. So
It
if
says that?
if we're gonna change this language, we should change the rest of it.
Yeah, because we don't bring people before the township board for violation of noise ordinance.
No. Okay, this might have been right from zoning ordinance 22. So anyway, that's a question for the lawyer.
Alright,
Okay, so the language, in other words, we have to give a license holder an opportunity to address the situation.
mhm,
That's their
right,
fraudulent complaints. Any person who knowingly files, and this is right out of boilerplate too, files a fraudulent or misleading complaint about a short-term rental shall be deemed to be in violation of this ordinance, may be subject to court enforcement proceedings and penalties under this ordinance. And misdemeanor infractions and or.
and there's a suggested rewording of that from the attorney as well. This whole section deals with that one phrase.
I didn't get there yet. Okay, so
Let's go with that.
that's in a
Fraudulent
Smith and
complaints.
Johnson
Yeah,
review.
and fraudulent complaints.
Then we get to violations. 6:12. Any of the following will be considered a violation of the ordinance if not remedied in a timely manner in accordance with the terms of this or other ordinances. Failure to update information with the township, such as the caretaker's or owner's contact information in a timely manner. If,
The timely manner, we should put a time limit on that.
yeah,
A timely manner, what, I mean, it was,
so you just put a period after contact information and cross out in a timely manner.
there should be a time limit.
Well, I understand that too, which. Actually, if we put within 30 days, that should be plenty. So if there's a change
So
in the
very
owner,
top, yeah, the first sentence, if not remedied within 30 days.
yeah. Okay, let's say failure to prevent on the owner's contact information within 30 days.
Hey, that's not where we're gonna go when it's going.
Advertising.
I didn't understand that.
Joanne's online,
Oh,
so.
Advertising a short-term rental for capacity in excess of that allowed under the license issued by the township. Failure of the license holder for his and her designated caretaker or agent to be available in a timely manner after reasonable attempts to contact them for issues of immediate concern in connection with short-term rentals. In other words, that goes back to our 60-minute timelines.
And then, the attorney said it would be beneficial to identify who would be attempting to contact them.
Okay,
Is it a violation regardless of whether or not it's the renters, a township representative, or even law enforcement authorities trying to make contact with them?
okay, so we need to put, the CEO or the sheriff. Code enforcement officer.
Yeah, got that.
Providing false or misleading information on the application. Failure to obtain a short-term rental license while operating a short-term rental is defined by this ordinance, which means item E, okay, you're not only in violation of this ordinance, if you're not living on the property, okay, you're in violation of ordinance 22. So failure to comply with any of the standards under this ordinance. Okay, fines. Any person, license holder, or caretaker who knowingly violates any provision of this ordinance, including above, shall be subject to the following fines after notice of hearing described in the section above. Now, the caretaker and the license holder would be the owner. Okay, so, caretaker basically has nothing to do with this. If you're gonna find somebody, you're gonna find the license.
Mm-hmm. There's scratch caretaker.
So. Okay, so could put A or each license holder who knowingly violates provision of this ordinance, including above, including the above, including those above. Actually, shouldn't be, that shouldn't even be there. Just scratch it.
It's,
Any provision of this ordinance shall be subject to the following fines after notice of hearing described in the section above. First violation for each short-term rental is $500. Now, I pulled these numbers basically out of three different other STRs and took what I would describe as a conservative average. I mean, some of them are, you know, first violation, $2,500. You know,
I don't see the problem with that.
basically the premise here is to, establish basically a border, a starting point. Okay, and then, as this thing works its way through being enforced or challenged, okay, the next board,
There's another recommendation by the attorney to say up to
right?
on each tier. Because there could be different levels of violation, I guess. You know,
Well, if you're gonna start
that's what he said.
assessing fines on a graduated scale, it's
Yeah,
like I asked these people a couple of meetings ago. I said, who among you rents your short-term rental for less than $500 a week? And I didn't see a hand go up.
You won't see one.
Okay. So.
so you want to stick
for
to the
what
hard
they-
and fast for no matter what the violation is, I mean,
Right,
seems like.
now, if you're actually gonna,
You're gonna give them a violation.
You're
for
going
not
through all these
advertising their
steps.
license number.
you're going through all these steps. Okay, to basically enforce this thing and write a violation,
Yeah,
somebody's gotta pay for
for sure.
it, okay? Second violation, I just graduated 250. Now, the third violation in red says, and suspension of the license. If the same license holder at the same property or the same license holder period at several properties basically is repeatedly going through this, that's when you have the hearing to revoke the license or suspend it.
Yeah,
All right,
that's under suspensions. Yeah.
so I don't know if we should address that here. Because the language prior to this says that the license holder has the right to basically request a hearing in front of this board over the suspension.
Right.
Okay, after that point, it goes to court. So. Which was the intent of the language with the township board, so. So basically we'll clarify that with the lawyer, because we should have, look, this is a community.
Mhm.
Okay, they should be able to come to us and say, what the heck is this? All right, this is what happened, and this is what, you know, your written report says, and, all right, and we can go from there. But that's before it ever gets to the legal process,
Mhm.
which is why I wrote that. So anyway, if the fines are fine, we can move on to the suspensions, which is where this gets sticky. When a short-term rental license has been issued, citations and violations 3 times, the township board with good cause may, but is not required to, revoke the license after notice and a hearing is provided herein. And that's where we get into the legal. So, come on. Yeah, okay. Any additional violations committed by the license holder within 2 years of the expiration of a suspension shall be grounds for a second suspension. So in other words, good behavior for a 2-year after we suspend the license for the remainder of that calendar year. Okay, which means we're probably in for some legal issues. If you reinstate the license and the license is valid, right, for 3 years. So you suspended it for the remainder of the year. The remainder of the license is 2 years. Okay, so we don't want to see any more violations. within that, and that would be subject to, again, another hearing with the township board. Okay, shall be grounds for a second suspension. If more than 2 years since the expiration of the initial suspension, any subsequent violation shall be deemed a first violation. Lawyer say anything about that?
Not that I remember.
Okay, the length and time of suspension, 6:15.
Yeah, today.
The suspension shall generally be effective of the following calendar year, beginning on January 1st, or
Oh, it's again.
The
that
current
is not
calendar.
required.
so. So we either suspended for a full year. So the first suspension would be 1 year, the second suspension would be another year, the third suspension would be revocation of the license and the retirement of that license. Which means the cap on the number of licenses would go down by one. That license would not be up for renewal. And that way, we can basically give the township board some way to control the number of STRs. in Clearwater. So,
Are we saying that the guy gets his first suspension Memorial Day weekend, he continues this year? And he doesn't.
right,
Spend it.
well, all right, so this goes into
It doesn't
effect,
say that.
this,
Well, it doesn't say when it starts either.
Effective, oh,
okay,
the following.
suspension
calendar
shall
year.
generally be effective the following calendar year, so what, if you're gonna suspend a license, that means pretty much you've been operating all summer. And in the middle of the summer, you get 3 violations after repeated, incidents at this particular STR. All right, and then if you suspend it for the remainder, well, it might be Labor Day.
Well, you can suspend it for 365 days,
Right.
Which would be,
From the date of
So
suspension.
from the date of the suspension, so that.
Yeah, I mean, yeah, I see what Greg's saying. It looks like what you're
So
saying is you
if
can
you
have 3
do that,
violations, but you can still operate until January 1st.
Right, okay, so, yeah, well, might have been a long day. Okay, so, I'm looking at 3 other ordinances while I'm trying to do this, plus the lawyer stuff, so if you're gonna suspend something for 1 year, we need to state that suspension shall be effective for
365 days from the date of suspension.
Yeah.
365. Beginning. Actually, from the date. Okay, hopefully, you never have to use this,
Yeah, correct.
but it's in there in case. Okay. Third suspension, basically. I was gonna make that under the second suspension, just revoke the license. If you're having 2 suspensions within a given license period, that means 2 out of the 3 years you're not operating. All right, so, what's the point? You didn't learn anything the first time. But,
But you give them a chance here 2 times to learn.
yeah, I'm basically,
Third time you're
I'm a 3 strike and you're out rule kind of guy, but.
Because, each one of these suspensions are gonna end up in courthouse.
Oh, yeah. So 3 strike rule is okay now. And the board would have to vote on suspending the license. Revoking it. Suspensions and revocation. The foregoing sanctions are in addition to the township's right to seek other appropriate and proper remedies, including actions in law or equity. This ordinance shall not apply to use of property by the property owners and their guests. That's a repetition of the
Yeah, I
original.
think that was recommended.
Okay, which was on, I believe, the preamble somewhere.
Mhm. The attorney even said that that shouldn't go there.
Okay, Article 7, enforcement officials, the township ordinance.
Wait, hold on. Under suspensions, in number 1, you said that, when a short-term license has been issued, citations or violations, the township board with good cause may, and again, you said, but is not required to, and the attorney says not to say that. Don't say, but is not required to.
Where's that at?
614 suspensions. Item number 1.
Yeah,
You want to cross out?
But is not required to.
Cross
but it's not
out.
required.
Mhm.
Are we
With
crossing
good
out?
cause may revoke the license after the notice and hearing. Okay, yeah, we kind of skipped over that.
And then. Under 615, item 2. The attorney said it is advisable to specifically add the availability of municipal civil infractions here as a potential remedy. The foregoing sanctions are in addition to the township's right to seek other appropriate and proper remedies. He's saying,
Including actions in
He's saying you
municipal,
should
municipal
specifically-
civil infraction is wrong. That's what we're doing.
I'm not really sure what he's
I
saying
think
there.
he's probably
He's saying,
referring to the noise fireworks ordinances.
These are sanctions. These are after the civil infractions are written.
in addition to the township's right to seek.
This is after the fact. The civil infractions are long gone.
It is that statement right there that he says right here in his recommendations. That very statement, the foregoing sanctions are in addition
In
to the
addition
township's
to,
right. That's that sentence that's right there, number 2.
right,
And he says it is advisable to specifically add the availability of municipal civil infractions here as a potential remedy. So the potential remedy is the civil infraction. I think that's what he's saying. I don't know, you can ask him.
well, the thing about it is the civil infractions have already been issued, or there wouldn't be a suspension or
Right.
violation. Okay, I'll put all this in an email.
To the wrong area.
I mean, this is after the fact.
Or just leave it and see what he
What
says.
it is basically, we're telling people, you know, the township has the right to sue.
Mhm.
Article 7, enforcement officials, township ordinance enforcement officer, which is zoning administrator, or other official designated by the township board, which would be the code enforcement officer. Okay, is hereby designated as the authorized official to issue or cause to be issued municipal civil infractions, directing alleged violators of this ordinance to appear in court. Calcasieu County Sheriff's Department may also enforce this ordinance. The township board may appoint an enforcement officer to assist the zoning administrator. So that would be our code enforcement officer. Whose basic responsibility would be STRs. Yeah, so the zoning administrator could handle the zoning administration. So that job description would have to be, written. And, I did kind of a basic one.
You had given us one before.
So, anybody have any problem with number one under enforcement officials?
No,
Enforcement action. In addition to enforcing this ordinance by a municipal civil infraction proceeding, the township may initiate proceedings in the circuit court to abate or eliminate any recurrent violations of this ordinance. In other words, we could just take them to court. Validity, if any section or provision of this clause of ordinance or the application thereof to any person or circumstances held invalid. Such invalidity shall not affect any remaining portions of our application of this ordinance, which can be given effect without the invalid portion of our application. Effective date, this is supposing we get through a public hearing and legal. This ordinance shall become effective October 1st, 2024, after its publication in the manner provided by law. Declared adopted, yada, yada, clerk's certification, that should say. Not certificate. And the date. A notice of adoption shall be published in a newspaper of general local circulation in full or summary.
So is there going to be a public hearing?
Yeah, that would,
when
have
we get it back from
scheduled,
the attorney.
once we get this back from legal and get the T's crossed and the I's dotted.
Yeah, so we make
Okay.
those final changes.
We'll make the final changes,
Well, we have
and
to have
we'll
one more.
schedule a public hearing.
We'll have to have one more meeting with the final changes
Yep,
to actually approve sending it to the attorney.
right,
I
and
think we
then,
should, yes, we should get this final copy and then go over it
right,
before we send it to legal.
basically, here's what I intended to do. We'll make the changes as suggested. You can send me the, language that, we've got for this process.
Mhm.
Okay, I'll contact the lawyer, any questions we have on this, make the changes in red letter. All right, and send it out to you. Hopefully, we can have this by the 18th. If not, we'll schedule a meeting just to review it. Okay, schedule a public hearing. Okay, advertise the public hearing. And then, the full board will vote whether or not to adopt the ordinance as is or amend it further. But the public it will be their meeting. All right, that being said,
Well, I just wanna go back to the fines real quick.
okay,
National Security funds. I mean, I think 500 is fine for the first, but we don't really make sure that they know we need business. I think that $5 should double. And then it should double again on your.
Yeah, that was-
Violation.
I was looking at that and saying, okay,
Because they're making,
first offense, $500,
I mean,
which is,
that's nothing for them,
that's reasonable.
reasonable,
Okay. The second violation, you wanna make a point.
yes.
So what you wanna do is double that, and for the third violation, you're looking at a $2,000 fine. And the possible suspension of that license.
Yeah.
I'm with okay with that.
You know, I just can't see us getting to that third violation, but. So what we wanted to see is 1,000 for the second and 2,000 for the third.
Think it's maybe.
Okay. Any other,
No, and then until I see our final,
Yeah,
well,
okay, public comment? Yes, sir.
Yes, good evening. I have a few things to say. I'd like to get them all out, for secure recorded.
Yes.
Yes.
First of all, I have a problem with the goal of this ordinance, okay? I think the goal of the ordinance should be to protect the property owners, which are taxpayers adjacent to rental properties. They're the ones that bear the biggest brunt of a lot of these violations.
Right.
That's the first.
I understand.
I gotta find the rest of these pages again, in just a second. And then a lot of notes. And as a property owner, as a taxpayer, it concerns me that the goal is not really clearly stated, okay? When we get to the reviewed and amended, this point,
Right,
606, this is really confusing. Number 2, the overnight occupancy of renters, tents, RVs, campers, or boats during periods of short-term rental is prohibited, okay? We had a lot of conversation about trailers and renting trailers. Is it legal to rent a trailer out in the township already, or are we getting too far into the weeds about trailers? So that's something I'd like you to investigate. What's going on, okay?
What was that?
Let me get all this. Okay, so prior to licensing somebody, I think it should be required to inspect the septic system. I don't care if the neighbor's well,
it's in there.
but it should be required before they get a permit. It should be inspected completely. So I want to make sure that's important. And then okay, some of this stuff, I mean, you blend some of your stuff into civil disputes, so it seems as though you have a lot of wording in here that seems as like it's quality control for this person who is renting the short-term rental property. Those people are not our concern, okay? That's a civil matter between the person renting the property and the property owner. A lot of the things that you're talking about in this property, okay, the town doesn't need to get in the weeds with information or someone's dissatisfaction with the rental property. That's an agreement between those two people. They have a contract separate from what's going on here. So all the stuff you get involved in with there is a waste of time for the town. If I'm renting a property and I have a problem, it's between me and the person renting the property. I don't care if the person can show up to help them and fix their toilet or do anything, because it doesn't matter to me. It matters to the person renting. We're not trying to protect the rights of the renters, okay? You're trying to protect the people of this town, people who pay taxes and have to put up with what's going on next to their homes, okay? You're talking about septic systems that are designed based on bedrooms. Well, there's a lot of rules that can be broken with bedrooms, okay? If you have a 3-bedroom house, and you're considering that there are 1 to 2 people per bedroom, which is a normal way to consider a house, and a septic system, okay? A lot of these houses have high-capacity bedrooms. They've got 4 bunks in them. So if you have a 3-bedroom house, you got 12 people in that house already. A 4-bedroom house may have 14 or 16 people. So you're not thinking this through. I'm the neighbor. There's a 3-bedroom house next to me that's designed for 3 or 4 people, and they're flushing the heck out of that septic system.
What does
My
it say?
well is 75 feet
What
away.
does it say under limitations in R1?
Well,
12 people, yeah.
Well,
Yeah, but the house is designed with 3 bedrooms.
doesn't matter, you can have 12 people in it.
Can you have 12 people in a 3-bedroom house?
Yeah, well, you can have, well,
That's not a real extent.
no,
You're saying the renter, that they can rent.
what I'm
12
saying, the maximum, the cap on
Capacity.
R1 is 12 people per STR.
I'd like to talk to the septic
If the-
system inspector and then get his understanding of how many people are in a 3-bedroom home.
If the septic
That's the,
system
yeah, that's
will
the
not
maximum
support,
limit, depending on the septic and.
No, it's a concern to me because every one
well,
of
I
these places,
understand.
every one of these places is gonna put as many bunks or as many beds as they can in the property.
That's been the discussion, yeah.
So the township, again, is not responsible for quality control. I don't think that should be any concern. Short-term rentals are not, they're not taxpayers. And And again, you're here to protect the rights of the people.
That's what we're trying to do.
You can focus on that.
So we're trying with that and protect the water.
I happen to be adjacent to a rental property. Okay, and I wasn't adjacent to a rental property before the house was sold, and it's gone from night to day, and it's not a good situation.
I understand that.
So, but I expect to see a little bit better language in this proposal to protect my rights. And oh, there's one more thing in here, really,
Can I make a
really,
suggestion?
really insulting, eh? Sections. There's a section in here about. On the bottom of these pages. Fraudulent complaints. Any person who knowingly files a fraudulent or misleading complaint about a short-term rental shall be deemed in violation. Does that mean me, as a property owner next to a rental property, is in violation of this law? And the other side of it is this already means to dispute fraudulent.
That
You've
language,
heard of defamation, you can sue somebody for a fraudulent complaint, you don't need to have it in an ordinance about a property, okay, so.
basically, it was just, to make sure that any complaint that we get, that the zoning administrator gets, or the code enforcement officer gets, or the law enforcement officer gets, is based on valid information. Okay, instead of having the same person call about the same situation over and over.
But that's what's gonna happen if I live adjacent to one of these properties, I'm gonna be calling about the same
Can I
thing.
make a suggestion? Why don't you take that home, highlight it, put your questions in an email, send it to me, so we can have either legal address them, or we can address them at the next.
And I'm gonna state something, I'm not against people renting their properties. And there are a lot of responsible people that do rent their properties, but to friends and relatives or people they work with, and they're very clear about the rules. But there are people who don't have regard for anything but the money and the income they get from these properties.
That's why we're doing this.
Okay.
That's why we're doing this.
Can I make, not just send it to the supervisor, but send it to the whole board?
Yeah,
That way,
I don't. I work at 3 locations throughout the state, I don't have a lot of time to get your information.
No,
Is there-
You
where
send
can I
it,
get the
you can
information?
send it to the
Send it
clerk
to the
or me,
website,
and
send a
we'll.
message on the website.
Okay.
It'll come to everybody.
All right, thank you.
And like I said, you'll have a chance to, address, you know, any errors or changes that you might want to see in it at the public hearing. But before we get to that point,
Yeah.
okay, we want to make this as clear as possible, run it through legal, make sure that, our Ts are crossed and the Is are dotted legally. Okay, and then hold a public hearing, and any other issues that need to be addressed at that time. It'll be your meeting, basically, time to convince the board, either to change something, scrap it, or start over, whatever, but in order to regulate and enforce the, shall we say, non-compliant, disrespectful individuals that are creating your problems on Crystal Beach and other places, we need to have this enforced so that we can tell them, knock it off, or tone it down, or leave, sell the property and go elsewhere.
Thank you. I would say, not to waste your time on language protecting the person renting the house. And I don't care if somebody can show up and they show up 300 days later. It's not gonna help me that they get there in 60 minutes. It's gonna help the property person renting the property. I think this has to have strict enforcement. Don't worry about all those other details.
Well, that's exactly why, we reinstituted the contract for the deputy sheriff and we doubled the hours. Basically, so somebody's here on Bristol Beach, Oils, and wherever he's needed.
There was a call at the property next to
And
my house.
this
several days ago,
ordinance-
I wasn't the one to call.
The fees from this ordinance, okay, will help support not only that, but another officer who's there for enforcement. So between the two of them, we should be able to impress upon the quote offenders, unquote, okay, that we're serious about this. And we either want them to, respect the community or leave.
I agree. Thank you.
Yeah, I have a question. My property on Arwood Trail, I have a driveway that as you pass through, you go off of Arwood and you pass my home, and then you go to the two other new, whatever you wanna call them. It's a nightmare, but, that dirt driveway, I've maintained that, with my tractor now since 1995. I get a couple loads, 22A, roll it out, take care of it. The traffic right now on my drive, my kids are here with dogs and stuff, and it's terrifying. Kids, they're running through that driveway. It's insane. It cuts across my property. And I'm trying to stay calm, but it's just not, the people that are coming have no respect for deer, my dogs, and nothing. You know, have trouble. And maintaining it is my own, it's me now. They're not helping me now. The people that moved out used to. And now the people that are running this, whatever the hell you wanna call it, I'm getting no help from them. And I don't know how to, get a hold of anybody if I were even going to. I don't know if I want to. But if I wanted to try to get somebody else to help get me some gravel, I'd still pull it. Then do I wanna make the road better because they'll just go faster? So anyway, that's my problem. It's not everybody.
I don't understand the specific situation there, but if you,
It sounds like he's got some renters down the road that he maintains that used to be nice people, and now there's renters down there, and they're
Okay.
pulling it down the road.
The only houses, yes, I had to go by my house and the next two wonderful, beautiful houses are now filled with people that are just raising hell. And they have to go across next to my house and cross it to get to those.
okay, I'll give you Deputy Creighton's number.
That's what I was gonna also ask you, because you're talking about people coming, and I don't have a number.
Right, so he can go out there and, basically make his presence known to the people.
Isn't the owner, you were at our last meeting, and isn't the owner out of state?
I have no idea.
Or that's what it was?
They are, I'm sure, there's nobody anymore that they send, yeah, they contract to take care of the things. I mean, it's so commercial. This is ridiculous. I live it's heaven there. It was. And now this is just like, it reminds me of, going to, they're wrecking this place. Now, it's heartbreaking.
Well, you know, Mr. Chair, if I may,
Go
I
ahead.
mean, that might be a perfect example where restriction is called
Right.
for, you know?
That
I
is-
just want
that
to
is
bring
part
this
of
up as zoning administrator. My responsibility is to the residents of this community. So that's one of my major concerns here. And this is fact. I've had probably 2 to 3 emails or phone calls a day solely on people trying to invest in short-term rentals. To me, that's not, and this is my personal opinion side of this, that's not what our community is about. Because like I said, my job, my responsibility is to you folks that are here today. And I'm not opposed to the short-term rental, but I need to look out for you folks, and that's what I'm here for.
Everyone knows short-term rentals increase property values. It shouldn't, but it does.
Right, so there's a lot of.
That's because they overpay.
It brings in more investors, it raises the property.
John, can you get with this gentleman after the meeting, if
Absolutely,
you would, please?
absolutely. So again, I want people to understand that's my responsibility to the people that live here. And I will help people out. I'm not saying you have to be from this area, but you have to think about the people that are surrounded.
Yeah.
Yes, sir.
I'd like to talk a little bit about the capacity limit under 6.053. It's a little confusing to me. We talk about, this thing appears to be based on B, which is the capacity limit as determined by number of bedrooms from the health department. Is that correct?
That would be everywhere except R1.
The health department is going to tell you how many bedrooms that the system is designed to accommodate. And limiting it to 2 persons. And this is where it gets confusing. 2 persons over the age of 18 for legally conforming bedrooms plus 2 more. But nobody under 18 counts. That's what it says.
Yes,
No, so going back to the septic system, if you're limiting it to 2 persons per legally conforming bedroom, but anybody under 18 doesn't count in that, you could easily double or even theoretically triple that 2 per bedroom capacity. And I could promise you that I have a 10-year-old granddaughter and she easily uses double the water that I do. That's a fact. I mean, anybody in this room that has teenage kids will tell you that they use a ton of water. And all that's going back to the capacity of the septic system, which these properties are going to be rented out to the capacity. If it's a 2-bedroom and you're allowing 2 plus 2, that's how many people are gonna be in there. Plus anybody under 18, and I just don't get it. I thought we talked about this at the last meeting. And that's why we came up with the capacity limit of 12, the maximum of 12. But it's still saying that even at that the number, the age, under the age of 18 don't count for that limit. So we're overwhelming. We can overwhelm.
The maximum capacity in R1 is 12, regardless of what their age is. Doesn't have an age restriction on that.
Well, then we need to
You need to make that a little clearer.
Okay, so
Regardless of the number of bedrooms.
It's in item C if we're moving.
But it also goes under the R1 limit of 12. There's exceptions to be made for special occasion, I believe is what it's for. But you can, in R1, there's a limit of 1 rental per 7 days as a minimum, right? So in a summer's time, that allows 3 weeks. If they're requesting or granted 3 exceptions, that allows 3 weeks with no capacity limit. There's absolutely no, they could double, triple, quadruple the capacity in that 3-week period.
that would depend on the septic system limitation.
It doesn't say that.
No. If it's, in other words, the request can be made. First of all, what's the location, what's the license number? What will that septic system handle? Is it a 6-bedroom house? How long, that would be at the discretion, okay, of the code enforcement officer to look at that specific location.
Is that putting quite a load on him to do?
And say, can this septic system handle this? All right,
Would it maybe be better to just allow for special occasions during the daytime from the hours that are not the quiet hours from 8 to?
well, if somebody's,
10 p.m. But the overnight capacity is limited to the 2 plus 2.
so basically what you're saying, that somebody's traveled here from out of state, basically has to rent a motel or try to find a motel when,
Capacity is capacity. I mean, yeah, we're still over.
okay, we can beat this to death, okay? But basically what I'm looking at, in R1, the capacity is 12 regardless of age, okay? If you're gonna have a family reunion and the house and the septic system can handle that number of people, that would be on a case-to-case basis. the code enforcement officer would check the location, look at the septic system, the number of guests, the period of time.
And I understand. that. So-
Okay,
So maybe we should reference that.
And if he had any questions about it, would basically contact us.
Maybe we should reference that and further in the wording.
Okay, yeah, that has to be addressed, I understand that, but I wanted to make the provision so we didn't exclude the reunions.
Right.
Because my family does the same thing, once every 5 years, we gather in California or Massachusetts or Michigan, okay, 56 of us. We rent an entire resort when we do this. Okay, we book an entire resort. That's not possible, but to exclude it, when people have been coming up here for decades, doing the same thing over and over again, to me, punishes somebody that's been coming up here for what we are.
But they're still renters, they're not taxpayers.
No,
So what do we owe those renters to be able to come up?
no, I understand that, it's,
Run a capacity.
Mr. Chairman, but the owners of those homes are taxpayers and they pay a lot of taxes.
right, we understand that. You know, but to not provide an alternative and just say,
It's public comment.
okay,
I continue on, so maybe the wording should be changed in that exception to reference the available septic capacity or something. One more I'd like to talk about was that regarding the auxiliary living space, I think it calls secondary dwelling unit or something in here. Earlier this year or late last year, the planning commission heard a couple of special use permit applications regarding the auxiliary living spaces. And one was, the request was they wanted to put in a auxiliary living space and rent that out, even though the previous, the primary was being rented out to another individual. The person did not live there, so they were essentially putting two dwellings, two living spaces, two residences on one property in R1, but it's a single family zone. So I think it's important to know that in R1 being zoned as a single family residential zone, that you likely should not put or allow secondary dwelling unit to be rented unless it's in conjunction with the primary residence. Does that make sense? You can't rent them out separately. You can't live in one and rent out the other one. It has to be a single family situation. So one family rents out both, or one is vacant and the other one's rented out.
now you would need to license 2 buildings,
Correct.
okay, and make sure the septic system supported it.
That's correct. But the point is you cannot live in your primary home and rent out your auxiliary dwelling unit.
That's called a commercial enterprise and which is allowed if you're living there and it's your primary residence. It's a family operated commercial business, which is allowed as a permitted use under zoning ordinance 22.
And it's not single family residence, is the point that the planning commission made. Because now you have 2 residences on one property.
Mr. Chairman, that used to be in the ordinance that was reviewed by the planning commission and then by the board, and it was removed. And it is stricken from the ordinance.
The auxiliary living space.
It was provided as a right of the people to use
In our-
that auxiliary living space.
Okay, something to research. Because I know. Okay, anyone else?
Hi there, my name is Joe Panovich, I'm a owner and taxpayer.
I want to say 3 quick points. Rebecca, one, as an owner, but also a person who feels that people should be entitled to rent their property. We're also taxpayers and we do respect the fact that folks that live locally or here full time are also taxpayers, but all of us do have rights, and I think that's what you're trying to balance here. I do want to address the second point, because I think there may be some confusion in the room. And so I'm a lawyer by trade, although I don't do this as my practice. As I read the ordinance, what you're trying to balance in the numbers, just to address, for example, your concern, a 3-bedroom getting overstacked. I don't think that's what you've laid out here. And I think just for everybody, to direct everybody's attention to the language shall be the lesser of. And that's the key qualifier. So if we got a 3-bedroom, even if you could max out a bunch of kids, you fall under the 12-person maximum. So you can never go above that 12. By the same token, if you had a 10-bedroom, you're still stuck. You're with 12 people. And I understand your point about the reunions. It's a case-by-case discretionary decision by the code enforcement officer. So, unless the code officer says, A-OK, I'm willing to have a 56-person reunion for 3 weeks of summer, it's not happening. So I do think
And if there's a question, he'd basically refer it to the board anyway.
so I do think it's a fine balance, that nobody is perfectly happy with all of those, but I'm just pointing out, and I think sort of the confusion is this lesser of that. As I read this and understand it, and you can let all of us know if you mean something different by it. That's the qualifier. You catching people on either septics, the 12 maximum, or the 2-person limited, 2x2 limitation. I did want to address one point, though, that one suggestion on the fines. I think this was the intent, but it wasn't clear to me. So you got a 4-year license. Is the intent, let's say you get a $500 fine in year 1, and you don't get your second violation until year 3, and maybe a 4th in year 4. Are you suspended at that point, or is it like within every 2-year period? I think based on the suspension section 6.14 that comes after it, that it's within a 2-year period. So in other words, like, the same, if I got a fine in year 1, I go 2 years with nothing, shouldn't you be back at square one?
Then you're back at square one.
That's not entirely sure, I think that's the intent.
That was the intent.
Yeah.
I don't know if it's clear enough, but
So to the point of capacity, who enforces the capacity?
I think that's our code enforcement officer.
How does he know when someone with a 3-bedroom house, how many people show up, or how many guests come over after they rent the house?
I mean, I'm assuming this is,
Watch 3 cars come into the house next door, and then their friends and their friends come over, and then now the house is over capacity, no one's enforcing that. No one has any way of knowing how many people are on the property and how many are guests, and they could say they're just guests, they're coming over for a couple hours, yet they're putting up hammocks in the front yard to sleep in overnight.
well, I mean, I assume.
okay, we're having a debate here.
How do we, I don't enforce that capacity, because it's a real issue for me.
I mean, I assume you would take pictures of it or call the code enforcement officer, have them come over,
Yeah, but now it's my responsibility
All right,
to do all this extra work
and it should be.
on a nightly basis in the summer.
we'll figure it out. The fact of the matter is in the calendar, okay, we have a reservation list that's supposed to be provided on an annual basis. Okay, this week, this license, this address will be rented to these people, a party of X. Okay, if the code enforcement officer goes by there at 10 o'clock at night, or the law enforcement officer goes by there at 10 o'clock at night, and there's 6 cars parked in the driveway, and there's 14 people in the house, we've got a problem. All right? If he goes back at midnight and the lights are out, and those 8 cars are still in the driveway.
I know, there's 2 ifs in your sentence.
Right. But what I'm saying is this is all. is going to get massaged over time. We're gonna figure it out as we go. The thing is, we can't do anything without it.
I understand, and
And what you're seeing, his phone calls added to my phone calls, added to the office phone calls. I've had 4 different realtors contact me in the last 3 weeks. He's had several, and he keeps fielding them at the office. Everybody wants to pay 3 times what a property is worth to get a house on one of the lakes or a river here.
I agree.
Okay? Which affects all of us. They go home. We pay the taxes.
I get it.
All right, so if there's no other public comment,
There's still.
Mr. Chair,
Sue
just
has a comment.
real quick, can you clarify to the public that we have the zoning administrator now, we do not have a code enforcement officer at this point, so I just want the public to be aware of that.
right, what would happen is, first of all, the public hearing, if we approve this and it does go into effect, we have to hire a code enforcement officer. We have to set up a system for tracking all these licenses, violations, all that information, all the calendars. We have to issue the licenses and then cap that number as of January 1st. Okay, then create a waiting list. There's a lot of work to be done here.
That's
So-
my point to the public, is
Yeah.
that there is a lot of.
Instead of rehashing the same stuff over and over and over again. Let's straighten out the language the way we have it written. Make any necessary adjustments as we get this thing passed so we can get to work, so we can take care of the people that are disturbing you as your neighbor and the gentleman that just left.
Yeah, that's a pretty bad situation.
That was very sad.
I understand that.
How many licenses are gonna be?
Yes, ma'am.
I, would like to know, because he asked a question about campers and mobile homes.
Campers and cars.
Oh, the tents. Basically, what we had was a guy running basically a taco stand off a pontoon boat. Who said he was, operating, basically a residential business off Bristol Beach. Next to one of our access sites, Pine Drive access, as you recall. Okay, who rented off not only the trailer. But I got pictures from his neighbor of 5 tents set up in the backyard. And he was renting that space out to. So that's why I'm saying in this, I included the language, you rent the house, you rent the house. You don't set up 8 tents in the backyard and invite all your friends.
How about just a trailer on the property? Is that something that can be rented?
Trailer on the property, if it's licensed,
Okay, if it's licensed.
okay, which is why I included the language for RVs and campers.
No, they can't do that.
I think that's what gets
What?
why would
They
we
can't
have?
rent it out. Like a short-term rental?
Yes,
No, they can't.
they have to be licensed.
Why in R1 would we allow?
We're in violation of the ordinance in effect. The only time you can have any ability to recreational is in your house and stuff.
For
But they are renting them out. That's my point. And unless you include them, you can't regulate it.
Thank you. First of all, thank you for allowing us to speak. Appreciate it very much.
Yes, thank
It's
you.
hard on you guys, but thanks for including us all in the workshop. And nauseam, try to stay with me. I'm still on the trailers and the RVs. They should not be allowed to be licensed for short-term rentals, whether they're doing it today against ordinance 22 or not. They shouldn't be allowed for all the reasons I've already
Okay, so
read to the board.
Your argument is we enforce ordinance 22.
No, no, they shouldn't be allowed to be licensed for short-term rentals, period. Because they don't comply with any structure
But they're still being rented.
against the current ordinance today.
Okay,
So that's illegal today, pardon me.
okay, so the zoning officer right now should be enforcing ordinance 22. their prohibitions
Which
for renting
nothing
of campers
against
and
our-
RVs.
Yeah, but nothing
Okay.
against our ordinance officer, the township hasn't enforced camping on your own property forever. I've got up and down Arbor Trail, I've got
I understand.
addresses that people have a trailer, a porta-john on one, two campers and a tent on another, and they're there for months. And that's against ordinance 22, and basically that's also against, because they own the property, is against this ordinance. And it's not, it's never been enforced, it needs to be enforced.
I understand.
Now, back to licensing trailers and RVs. If you can't put a trailer on your own property and live in it, how do you license it for an STR? You can't justify it. Plus, it's a health hazard because of the waste. You can't be assured they're gonna take and dump it somewhere. You can't tie it into the.
So your argument is that they not be included in this ordinance because they're already included in ordinance 22.
They don't comply with anything. They're in 22 and they don't comply with the structure to be allowed to be rented as an STR. There are numerous reasons why. Plus, if you allow up, this ordinance allows up to 4 on a property, you're creating a camping atmosphere. And that shouldn't be, they could each have their own fire ring. They could
Those
each have-
licenses, they have to be approved.
Yes, but why would we have it in there at all? Why would it be there at
Okay,
all?
your point is well taken, and I would check on, the zoning ordinance 22 as far as the occupancy of or rental of trailers and RVs. Because this has been going on for years, and I know it goes on today as we speak,
Yeah.
all right?
Part of that is
Why
the law.
have an ordinance in place if we don't
Homeless,
enforce it?
homeless who have no.
We need to review ordinance 22. Yes,
I mean, to add to this gentleman's point, so I've come from the background that I've, owned property here for many, many years. I'm feeling a little ruffled, and I try to be responsible. I rent to families, I stay away from partiers, and everything that I've heard is the camping and the RVing seems to be highlighting what a problem is in certain areas, and it's giving people like me, I feel like a bad name. I can understand why some people may wanna have a camper for their own use, for maybe their family to come up and everything like that, and they wanna use it on their property, but even from where I'm coming from, I concur with not understanding how we're allowing an RV to be licensed when it seems like people who are renting out their RVs to, as short-term rentals is part of the problem, is putting a bad name on tax-paying owners like myself that are trying to do a good job and trying to be respectable. So I am puzzled by it as well. And I'm coming from that point of view.
Just
It's a little confusing.
dedicated, single-family residential. That's only a trailer. No.
okay, all right,
Sue's still waiting.
yes, so,
Just quickly, I've got about 4 points in menu, which you have heard. I want to thank the gentleman down here and John for bringing up comments on residents and neighborhoods. You know, that's been my constant chime for all of this. I live in a neighborhood, I live in an R1 neighborhood. And you all have decided to legislate commercial activity there. I hope that the information that you currently do get in your ordinance makes that somewhat tolerable. But obviously, and I've been to many of these meetings except for last year when I was traveling, there just seems to be a lot of confusion and a lot of questions on the language, what it means, clarification, different interpretations. So I hope the board I hope this board keeps an open mind to deferring final approval to the next board rather than rushing something. as been evidenced by this meeting and prior meetings, there's still some roads that have to be traveled and some questions that have to be answered and some interpretations that need to be decided. Lake duck legislation has a history of being very problematic, and I hope you don't fall into that same trap. Couple of things with respect to the current legislation that you're looking at. Accommodating large groups, it was defined as, Labor Day, Memorial Day, 4th of July. Those are my holidays too. Those are my holidays when I don't have family of 56. I have a family of 5. And we like to get together. I don't want to lose all my holidays because somebody else from somewhere else wants to bring all of their family up and park it next door for every major holiday. That's not taking care of the neighborhood, in my opinion. I wish that you would reconsider. Capacity limits, nobody under 18 counting. I don't have words. How can they not count? And for everything that we're trying to protect, with the water, the groundwater, the septics, with the lake, the streams, the rivers, with the runoff, with everything, with the noise, with the ordinance compliance, all of that, everybody counts. I don't care whether you've got teenagers at your house, or you've got babies. Everybody counts towards that. I hope that you, the other thing is that did you realize when you read through that, the only people that are limited are people who are actually 18. You can be over 18, you can be under 18. If you're 18, you're out. So you might want to put it in that phrasing. Lastly, and I've said this before, in the decision to conceive commercial operations in the residential area, I feel very strongly, as do my neighbors, and other taxpayers who don't live in my neighborhood, but live in what few of the other neighborhoods are allowed. Don't believe we should be having to board any of the expense that is assisting commercial operations in our neighborhood. The fees, the penalties, the license fees, the renewal fees should be enough to be able to pay for compliance issues, administration issues, which, and you'll be surprised at what those amount to. The time, as a taxpayer, that should not be on my back. I don't want to go to next year's budget meetings and hear issues and concerns over the legal budget, because now we've got all of these things that are causing us to have a lawyer involved in an opinion on here, or hearing on here. If this board's gonna go down that road, this board better know how they're gonna pay for it. And it should not be on my back. It should not be. I hope you consider that. Thank you for your time.
Thank you.
Well said.
Thank you.
Yes, ma'am.
I would just like to question you, you got 4 more months until the next board comes in, only one is remaining on this board. Wouldn't it be wise to, since the next board is gonna have to either support this or vote to get rid of it, wouldn't it be wise to carry it forward for them to decide for the next 4 years?
Yes, so originally, before we got into rewriting this whole thing, okay, the game plan was to try and have it finished and out the door in time to start issuing or basically making applications available by October 1st. That's not set in concrete. In fact, I just changed the date in this thing yesterday, about 2 days ago. Okay, it's been pushed back twice, at least. We've been working at this for 2 years.
Right, and the next board may not want some of that because it's gonna be too much.
I understand that. But the reason you're all here is to provide this board with the pros and cons of every word in this. and we've been listening. But the fact of the matter is, we have to balance your rights with your rights and your rights. And that's a tightrope. Okay? And I would like to have this as accommodating as possible to everybody concerned, but with restrictions as to conduct and to commercializing of the neighborhoods R1 as possible. And yes, that might take another 6 months, in which case it will be the next board's decision. But all of this homework and all of this discussion and changes all goes into the groundwork to handing them something that they can work with. All right, instead of starting from scratch or just throwing up your hands and saying, let the real estate agents buy Clearwater, because that's what's happening. And these are brokers, these are not, oh, I represent a client. No, I want to buy. I'm a real estate broker from. I'm looking at some property in Clearwater Township as an investment. What's that tell you? He's not gonna be a good neighbor.
I'd like to remind everybody that I believe all of these houses were built as family dwellings in a residential neighborhood.
Exactly.
They started that way.
They were built as vacation homes,
Okay, all right, but they were built as residential.
family vacation.
And then as people purchased those houses from those other people, they saw the opportunity for investment. So now it's a commercial enterprise. It's no longer in the spirit of the original zoning and the original neighborhood. So while you are a taxpayer, sir, you are taking advantage of a residential neighborhood to run a business.
That's not true. You don't know where I am.
Okay, all right.
Because they don't even have heat.
I'm not gonna sit here and listen to you guys argue. Okay,
Address the board too, don't address him, address the board, please.
All right, well, he addressed my comment.
okay, all
So
right. Is there any other public comment? So we can go home and start working.
We have a place on Christian Beach Road. Our house has been rented out since the 1940s. And it was not built as a home, it was built as a cottage to rent out
Before zoning.
before anything. Long Beach Road has been rented out for years and years and years. Now,
Historic.
these people over here have a small, nice little community. I can see where it bothers them, because that's not what they're used to. The Crystal Beach Road has always been busy, and always been rented out in that area.
I can see where your grandfather didn't have.
Yeah.
Okay, all right. All right, now we're having another discussion. Please, make your point.
The board, please look again at the capacity to allow anyone, including all these brokers calling up to find and search and grab a parcel of land or a dwelling or something, and they're gonna convert it over. To look at a percentage of homes for the cap and not how many want to by December 31st. Well, my research has shown me that the majority of communities, cities or townships, have gone and licensed STRs. The average is somewhere between 2% and 4% of the dwellings. So if you can do the math, and you're probably almost there if you look at all the dwellings in the township, approximately. But if you look just at the dwellings on where all the STRs are, on Crystal Beach, Armwood Trail, a couple other roads, we don't have the 2,500 buildings there, we've got a few hundred. And the density is so much greater in those areas, causing more issues than we want. Take a look at it, consider that, versus just anybody that wants something by December 31st. And that would shut off all these people calling too. They'll shut that off right away.
Okay, nice first step.
So basically what we need to do is tell everybody that calls that the capacity, maximum capacity cap in R1 will be 12 persons.
When they call right now, we just tell them it's not legal.
Yeah,
Well, yeah, and yes, that's true. But the capacity I meant for the total number of units, total number of STRs, not caps on 12, but the quantity of people in the dwelling. I'm talking about the capacity of all the STRs. That should be 2 to 4% tops on average.
you're talking about the number of STR.
Number of STRs.
About
Not,
that,
not how many want.
if you come up with, basically, a random number, okay, and the applications exceed that,
Wait in line.
okay?
I've talked to some of the other towns.
What if one of the applications is yours?
It won't be one.
You guarantee that?
Yes,
Okay.
I guarantee.
But what I'm saying is, who at that point do you deny?
For who? The people that already have them, that have been doing it?
No, what I'm saying is okay, the premise is, okay, once this thing's approved and it actually becomes an ordinance, legal ordinance, okay, the application period is 90 days. All right, basically October, November, December. All right, January 1st, you close it. That's your cap. From that point on, there's a waiting list, and as the licenses become revoked now, not suspended, okay, that cap goes down. If there's a problem with it, with an STR over and over and over again to the point where you have to pull that
But
license.
again, that's up to the
Or if the
board.
property is sold, or if someone passes on and the heritage.
Those
property
things-
goes back.
Those things are not what I'm worried about at the moment. The
No,
way to reduce the cap would be after this thing is basically enacted. If you want to amend it to, now you know what you're dealing with. Okay, you know how many you have. If we want to reduce them, we want to reduce them in this specific area. Okay, if we have a problem with an owner in this area, we revoke the license, that license for that address never gets issued again. Crystal Beach. Okay, somebody that wants to buy that property has to be told, you're not getting an STR, you can't rent this place out. All right, somebody has to live there, either for all summer or all year. So that's the point of this. I'm so tired of doing this. I would gladly hand it to the next board. But first, we have to have something that's structured properly in order to give them something that they can deal with and actually execute. All right, and yes, it shouldn't be this board's decision at this point. This has got at least 2 more meetings to go to. It's July. So,
thank you again, all of you. Appreciate it.
anyway,
Being a mail carrier for 32 years, along all the lakes, literally, the people with the most cars in their driveway raising the most hell are the residents who have all their family come up from downstate, and they're there all night. They're not renting it, but it happens. And I could name 15 of them right now, but there's a lot more than that. If you have a house on the lake, it's gonna be busy.
we have an enforceable noise ordinance.
Right, and maybe that should be the first step.
That was one of the things when I first spoke to Deputy Creighton. I said the noise ordinance, and I said, and now we've got a new blight ordinance.
But they're still using the toilet.
Okay, and he's writing citations for noise.
I have a question, so that the capacity 12 will apply only to STR
Yeah.
or to all residents?
Yes.
Not so, because we have regular residents who live here all year round, and they have
Are you running for more than 30 days at a time? Are you running for over a month at a time?
How about they're not renting?
no.
Not running it
They're
up.
not ready.
Okay.
So it's their company.
She's saying they just live there.
Companies and.
And no, there's no regulation on that.
What's that?
Right, there's not.
Oh.
There's no regulation on that.
That's right.
No,
Because we are just beating up SDR and septic and all that, and of course SDR, they want to make sure, because if the renters rented and all of a sudden septic fail,
they're gonna sue the owner because they ruined their vacation. So they wanna make sure the septic is up to date and working perfectly, because it's just a normal thing. Because that's what I would do. If somebody ruined my vacation, I would sue the owner.
Yes, I
Right.
understand that.
That's the way,
But at
so.
the same time, we have to basically make sure that the systems along Crystal Beach and Hoyles, because they do rent them out on Hoyles too, and the river, okay, isn't overloaded. And the only way to do that is to put a cap into the system for regulating the STRs. And the only way to do that is to regulate the STRs, which is why we're all here in the first place. Can we go home?
One final thought, as Jerry Springer likes to say, final thoughts here from the zoning administrator. If it's a law enforcement issue, you call law enforcement. If
Exactly.
it's 2 o'clock in the morning, your neighbors are too loud, or parties going on, or they're stealing your firewood, that's a law enforcement issue. It's not to say that I won't do something about it, but I'm not patrolling at 2 o'clock in the morning. And if our deputy's there, which we pay the extra money for, that's what we should be using them for, so.
Our contract includes enforcement of township ordinance with the sheriff's department, period.
Now, if it's the next day you call me, then I got documentation, at least I can document things like that, but I have a hard time, like I said, going to what's it at 2 o'clock.
Can
I'd
I,
love to do it.
can I have an illegal campground? I understand you can have 4 campers on your property, 1 piece of property without breaking state rules.
Right.
Are you guys enforcing that?
Anything over 5, if there's 5 campsites on one single parcel,
Or,
then if there's 5,
mhm.
now you have to have a license from the state. You will be reported to the state.
But you
Okay, and
can't,
let the DNR deal with it.
you can't camp in R1, no,
No,
you can't camp in R1. So in R1, you can't have a camper there for campers or trailers or anything.
Well, this is not charged, it wasn't that many dollars,
No, the owner can't camp in there either.
Yeah.
not for a night, you can't.
You're not even supposed to stay in it for a
No.
night.
No, I don't know property, no.
No,
Not an R1.
not in R1.
okay. Make a motion.
Motion to adjourn, I second that.
Thank you, Dan.
8:30. Couple minutes.